Hi everyone, myself Arindam and I'm a legal intern at LEXIS and Company, and today we'll be discussing on the topic of merger and acquisition regarding the Indian law. So without further ado, let's get started. A business identity goes for mergers and acquisition for strengthening a disjointed market and for elevating their functional competence in order to boost their competitive streak. Now many countries have propagated merger and acquisition laws to control the operations of trade unions within. Most of the mergers and acquisitions have been successful in elevating the functional competence, of companies. But on the flip side, these activities can lead to the formation of monopolistic power. The anti-competitive results are accomplished either by synchronized effects or by one-sided effects. Laws governing mergers and acquisition in India. Mergers and acquisitions in India are governed by the India's Company Act in 1956 under section 391 to 394. Although mergers and acquisitions may be instigated through mutual agreements between two firms, the procedure remains chiefly court-driven. The approval of the High Court is highly desirable for the commencement of any such processes, and the proposal for any merger or acquisition should be sanctioned by a 3/4 of the shareholders or creditors present, at the general board meeting of the concerned firm. So the Indian antagonism law permits the utmost time period of 210 days for the companies for going ahead with the process of merger and acquisitions. The allotted time period is clearly different from the minimum obligatory stay period for claimants. According to the law, the obligatory time frame for claimants can either be 210 days commencing from the filing of the notice or acknowledgement of the Commission's order. The entry limits for companies merging under the Indian law are considerably high. The entry limits are allocated, in context of the asset worth or in context of the company's annual income. The entry limit in India are higher than European Unions, are twofold as compared to the United Kingdoms. The Indian M&A law also permits the combination of an Indian firm with its international counterparts, providing the cross-border firm has its setup in India. There has been recent modifications in the Competition Act 2002. It has replaced the voluntarily announcement system with a mandatory one. Out of the 106 nations which have formulated competition law, India, only 9 are acclaimed with the voluntary announcement system. Voluntary announcement systems are often correlated with business ambiguities, and the companies are identified for practicing monopoly after merging. The law strictly orders that them opt for demerging of the business identity. Provisions under the Mergers and Acquisitions Law in India. Provision for tax allowance for mergers or demergers between two businesses. Identities is allocated with the Indian Income Tax Act. To qualify the allocation, identities is allocated, under the Indian Income Tax Act. To qualify the allocation, these mergers or demergers are required to fulfill the requirements related to Section 219AA and Section 21B of the Indian Income Tax Act as per the pertinent, state of affairs. Under the IT Act, the firm, either Indian or foreign, qualifies for certain tax exemptions from the capital profits during the transfer of shares. In case of a foreign company merger, a situation where two foreign firms are merged as the new formed identity is owned by an Indian firm, a different set of guidelines are allotted, and hence the share allocation in the targeted foreign business, identity would be acknowledged as a transfer and would be chargeable under the Indian tax law. As per the clauses mentioned under Section 5(1) of the Income Tax Act, the international earnings by an Indian firm would fall under the category of scope of income for the Indian firm. Because the firm is getting a profit, so that will fall under the scope of income for the Indian firm. Now, we learned about, two laws actually. The Indian Companies Act and the Indian Taxation Act. Indian Companies Act basically under Section 391 to 394. And the Indian M&A laws are not different, and we also learned about the Competition Act that has replaced the voluntary announcement system with a mandatory one, and then the Indian Taxation Act under Section 5(1) of the Indian Income Tax Act the international earnings also fall under the category of scope of income for the Indian firm. So this was all about the part of mergers and acquisitions laws in India. So to learn such other videos or know such other videos or know such different aspects of law, please do subscribe to LEXCLIQ and please do watch our channel. Thank you.